court next takes up the question of whether the death penalty is appropriate for certain people who commit crimes. In the Penry case, the court, in the Atkins case, the court looks at whether the death penalty is constitutionally appropriate for a person who's intellectually disabled. At the time these cases were decided, this was generally referred to as mental retardation, and that's the language that's in the court's opinion, and that's the language, mental retardation, that we see in many of the statutes. When we talk about intellectual disability or mental retardation, we're talking about a person who has substantially sub-average intellectual functioning, that is somebody who tests low on an intelligent quotient test, usually 70, 75, somewhere in that neighborhood or below, that the person has that and deficits in 2 or more areas of adaptive behavior, that is in terms of the person doing the day-to-day things that all people do in their lives, that they have deficits in handling things, making change, other things like that. And finally, that it was manifested before the age of 18. This appears in the Atkins case, Atkins versus Virginia, footnote number 3, where the court gives the definition of both the American Psychiatric Association as well as the American Psychological Association. There are slight differences in the language, but basically this is the description of mental retardation or intellectual disability that the court uses. Now this is interesting in terms of how the consensus, as the court finds it, develops. 1987, not a single state prohibited the death penalty for the intellectually disabled. By 1989, 2 states, Georgia, which was the first state to prohibit it, and Maryland, and the United States, which had adopted the death penalty in 1988, had excluded mental retarded people from those eligible for the death penalty. Then we come to 2002, which is when the Atkins case is decided. Now 18 states have held that the death penalty is not appropriate for intellectually disabled people. And the court looks at those 18 states, and this is the difference between the majority of the court and the dissenting opinion. It also adds in the 12 states that don't have the death penalty. So it reaches, and of course the United States government still doesn't have it. So the majority adds this up and says this is 30 states. Notice this is not nearly as overwhelming as in Coker, when you had 49 states, only 1 state had it and 49 states didn't, or Kennedy versus Louisiana, where a handful of states had it and 44 states did not. Here, the court reaches a total of 30 states, but that's counting the 12 states that don't have the death penalty at all. The dissenters argue that the states without the death penalty should not be counted, that the court should only look at the states that have the death penalty, and based on that, this is not constitutionally prohibited. The question here, just whether the death penalty is categorically barred for someone who meets the definition of intellectual disability. The Supreme Court talks here, as it will be talking about in other situations, as with children. How do we minimize the risk? Once we sort of survey the states, we see 30 to 20, according to the majority, and the majority also points out that in the 20 that allow imposition of the death penalty, it's very infrequently imposed upon people who are intellectually disabled. And then it sees factors that run the possibility or the risk that a person who's intellectually disabled might be sentenced to death inappropriately, that such people are less able to assist their lawyers in preparing and working on their case. They're less able to put on mitigating circumstances because, again, they may not have the intellectual capabilities of working with their lawyer and developing the evidence as a person who was not intellectually disabled would be able to. They're less able to testify. The court says they're typically very poor witnesses. Threat of false confessions. The court looks to the Earl Washington case. This was a fellow with a very low IQ, Earl Washington, who confessed to a number of crimes and was convicted and was sentenced to death, almost executed, but then Governor Wilder of Virginia commuted his sentence to life in prison, and then sometime after that, with the developments in DNA testing, it was shown that Earl Washington was absolutely innocent, had absolutely nothing to do with the case, even though he had confessed to doing it. But he was intellectually disabled, very susceptible to suggestion, and very willing to go along with authority figures in saying that he had done something even though he had not. And the court notes that in a footnote. The court also talks about the unwarranted impression that the jury may have that a person lacks remorse if they're intellectually disabled. And this may be because the person just simply doesn't have the intellectual capability of following the complex proceedings in the court, and so sits there looking sort of cold and unfeeling, when in fact they're just not able to process the information that's coming into their mind at the time this is going on. So the court decides that the death penalty is unconstitutional for people who are intellectually disabled. Then the court has over time looked at the question of the death penalty for children. In 1988 in Thompson versus Oklahoma, the Supreme Court divided 4 votes one way, 4 votes the other, Justice O'Connor making the critical decision that at least Oklahoma could not put 15-year-old children, and we're talking about when the crime was committed. That is, a child who committed a crime at age 15, not eligible for the death penalty. But then the court in Stanford versus Kentucky, 1989, upheld the death penalty for children who were 16 and 17 years of age, and that was the law for some time. And a number of children that age, or who committed their crimes when they were that age, were sentenced to death, and a number were executed. Despite the Stanford case, the Missouri Supreme Court decides in the Simmons case that the death penalty is unconstitutional for those under 18 at the time of the crime. So how can the court do that? The Missouri Supreme Court goes out on a limb just a bit, saying that based on Atkins, we think if the Supreme Court were to reconsider this decision, it would overrule Stanford and it would prohibit the death penalty for people who commit crimes when they're under 18 years of age. Well, the Missouri Supreme Court certainly forced the court's hand to make a decision about whether it was going to overrule its previous decision or not. But ultimately, the court does affirm in the Simmons case, Roper versus Simmons, and decides that the death penalty is unconstitutional for anyone who commits a crime when they're under 18 years of age. Just as in Atkins, that's the mental retardation case, 18 states prohibited the death penalty for people under 18 at the time of the crime. 12 states, of course, don't have the death penalty at all. And then you have 20 states that authorize the death penalty, but as the court points out, the use of the death penalty in those states is infrequent. And it points out that in particular, the governor of Kentucky commuted Kevin Stanford, the person who was the named party in Stanford versus Kentucky. The court notes that the governor of Kentucky commutes his sentence and says we're not going to execute someone who was a child at the time the crime was committed. So it finds that the use is infrequent even in the states that have it. And this, the court says, is sufficient evidence that society views juveniles as categorically less culpable than the average person. In other words, that someone who commits a crime under the age of 18, while guilty of murder, while certainly can be prosecuted as an adult, can be punished severely, even sentenced to life imprisonment without any possibility of parole, but that person cannot be sentenced to death. Part of it is looking at the states, again, 30 to 20, not nearly the almost unanimity opinion that we saw, a unanimity of views that we saw in the Coker case, but the same exactly that we saw in the Atkins case. But then the court took a lot of evidence in this case on, and got briefs from experts on the development of brains in young people and adolescents and people growing up, and found, as most parents would probably know already, that the brain development of someone who's 16, 17, 18 years of age has not, or the brain of that person is not fully developed, and that at that point people do not have as good a ability to make decisions, to make good judgments, and so forth. So the court looks at this factor and compares sort of the intellectually disabled and the children, both having an underdeveloped sense of responsibility, the court says. In addition to that, both are vulnerable, as we talked about just a moment ago with regard to the intellectually disabled. Both are vulnerable to negative influences and outside pressures. That is, they can be led into doing things that they normally wouldn't do, but because they're immature or because they're intellectually limited, they might get caught up in something. They do not make good decisions due to their intellectual limitations, or, as I talked about a moment ago, the lack of development, the lack of their brain, or what we would call immaturity. They have less control over their environment. Children really don't have much choice whether they have the good fortune to be born into a wealthy, loving home, or whether they happen to grow up in a domestic war zone where everyone is in abject poverty and where there's a lot of violence and killing and gang activity and so forth. So that is a factor that the court finds militates in favor of prohibiting the death penalty for children. And finally, the court says the juvenile character is not well formed, and therefore, because of that, children are less culpable. Again, not saying they can't be convicted of murder, but just saying in terms of whether we impose the ultimate punishment. Again, as in Atkins, we're concerned about risk. The court says here the difference between juveniles and adult offenders are so marked and well understood that we can't risk allowing a youthful person to receive the death penalty even though that person's not sufficiently culpable. And the court points out that it's difficult even for an expert in child behavior, a psychologist, to differentiate between the immature child and what he calls the irreparably corrupt child. And finally, an unacceptable likelihood exists that the brutality of the crime will overpower the mitigating circumstances. This is a questionable and controversial reason given in the case, because of course this is true in almost every death penalty case, that the horrific nature of the crime may be more overpowering than whatever evidence and mitigation is submitted. But in cases where a person is young, they don't have as much of a life and background as somebody who is older, and perhaps that's what Justice Kennedy was thinking about here. Then he looks at the purpose of punishment, retribution. The death penalty is our most severe punishment, and the question is, do we impose it on someone whose blameworthiness is diminished? Still blameworthy, but diminished blameworthiness due to their youth. And then deterrence. Is deterrence served? And the court finds that because children don't have the same ability to process information, to learn from their mistakes, to consider, to make good judgments and consider the wisdom of what they're doing, unlike adults, that the purpose of punishment is not being served by allowing people who commit crimes under the age of 18 to be sentenced to death. Justice O'Connor would ask a very different question here, and it's interesting. She voted for banning the death penalty for people who are intellectually disabled, but she dissents from this decision. In her view, the question here is whether by virtue of youth alone, the defendant inevitably lacks the cognitive, volitional, and moral capacity to act with the degree of culpability that we associate with the death penalty. In other words, she would treat each person individually. She said there could be a 17-year-old that when you look at the background and life of that person is sufficiently culpable that we should give them the death penalty. We may have an 18-year-old who is immature and perhaps not appropriate for the death penalty, but she would sort it out person by person because she says youth alone does not always mean. Now, the majority responds to this by saying we can see this point, but we're worried about the risk. We're worried about the risk of somebody whose culpability is not as great as other offenders receiving the death penalty. O'Connor writes only for herself in her dissent. Justice Scalia, on the other hand, joined by the Chief Justice and Justice Thomas, he says that, first of all, we shouldn't count the states without the death penalty. This is a point he'd made earlier in Atkins, and he makes again. We should only look at the states that have the death penalty on the books and see how many would allow the death penalty for those under 18 at the time of the crime and how many do not. He accuses the majority of bringing their personal views into the analysis, which of course would probably not be agreed to by the majority of the court. But then he also criticizes the studies that are cited in the majority opinion. He points out there was no evidentiary hearing in Roper on this question where this was subject to any kind of adversarial testing. That is, where doctors testified and were cross-examined and doctors on both sides testified, and the court made some finding with regard to the development of the brains of children and the other issues that were before the court. He accuses the court of looking out over the crowd and picking out its friends. In other words, making very selective use of evidence to reach the conclusion that the death penalty is not appropriate. He also looks and tries to discredit the American Psychological Association, which has filed a brief with the court saying that children who are 17 and 16 at the time of the crime are immature, don't make good judgments, and so forth. He points out that that same association filed a brief with the court that said at age 14 and 15, children could make a decision about having an abortion. He also points out that Article 37 of the Convention of the Rights of a Child, which is cited by the majority, it does prohibit the death penalty for this class of people, but the United States and Somalia, the only two states, only two countries in the world, have not ratified it. So he said, how could this possibly be the consensus of the United States or even relevant to the views of people in the United States when it hasn't even been ratified by the Senate? He believes very strongly that the laws of other countries should not be considered. And he accuses the court of citing the laws in other countries selectively when it makes those decisions. What the majority had done is made its analysis of the states, how many allowed the death penalty for this group of children and how many did not. It had then looked at the risk of the death penalty being imposed despite diminished culpability. Only after that, the court had said, and our opinion is confirmed by the fact that other countries in the world do not allow this. But it didn't really say it based its decision on it. It just simply pointed to the fact that other countries didn't allow it. But this is a controversial point. It's a point that comes up in confirmation hearings when people are nominated to the Supreme Court. Will you follow international law, or will you only follow domestic law, only follow the law of the United States? But as the world becomes more globalized, and as we all intend to interact with other countries and so forth, that may be, that view at least could be questioned as somewhat provincial, that we might look to other places and find out what they've done and learn from that. Well, there were two important decisions that flowed from this decision by the Supreme Court. The first one was Graham versus Florida. This is not a death penalty case, but this is a child, and Florida had a number of these children who were sentenced to life imprisonment without any possibility of parole that committed crimes where no one was killed. Joe Sullivan's case that was argued with the Graham case, where in a one-day trial, a 13-year-old child is convicted and sentenced to life imprisonment without any possibility of parole, no matter how well that child does in prison or as an adult that person does in prison, no consideration whatsoever. The Supreme Court says this is disproportionate and excessive for a child. And it looks basically at its death penalty decisions, and it looks particularly at what it decided in Roper about the development of the brains of children, about children's immaturity, their ability to make decisions, and it decides that this is too excessive or too severe a punishment for those children. And then the court decides Miller versus Alabama. This is decided in 2012, and this involved, again, life imprisonment without any possibility of parole, but for homicide cases. The fault the court finds, the challenge Miller made and the other person, there were two cases here, one out of Arkansas and one out of Alabama, and the challenge was that in these cases, life without the possibility of parole was automatic, that once a person was convicted of this crime, once someone under 17 or younger was convicted of this crime, the judge had no discretion, but the death penalty was mandatory. The court says you can't do that. It has to be individualized sentencing hearing, where the judge takes into account the child's age, circumstances of the crime, and other mitigating factors. It doesn't mean that a court can't, after taking all those into account, sentence a child to a very long sentence, or even probably life imprisonment without possibility of parole, but it says that the court it can't do it automatically. The legislature cannot provide that if you do a certain crime, they can provide that for adults, but not for these children. That if you do a certain crime, it's automatically going to be life imprisonment without any possibility of parole. So two significant decisions, because the court has done very little on the question of proportionality outside the area of the death penalty. Finally, we come to individual proportionality review. This is a different kind of question. We've looked at whether the death penalty is appropriate for the role of the offender in the crime. We've looked at whether it's appropriate for certain crimes and for certain kind of offenders, children and intellectually disabled people. Now, Robert Alton Harris, who was sentenced to death in California, comes before the court, and he's got a different argument. He says, I want a determination of whether the death penalty was disproportionate in my case compared to all the other murder cases and the sentences imposed in California. And the basis for this argument is that when the Supreme Court upheld a Georgia statute in 1976, in the case of Gregg versus Georgia, it pointed out and lauded the fact that the Georgia Supreme Court, under that statute, was required to compare each case to others and see if the death penalty was disproportionate, considering both the circumstances of the crime and the background of the offender. And so some people read the Supreme Court's opinion in Gregg to say that this was constitutionally required. Of course, the court also upheld the Texas statute that day, where there was no such provision in the statute. Florida had decided judicially to conduct proportionality review, but it was not in the statute upheld in 1976. Well, the court decides that the Eighth Amendment does not require the proportionality review that Harris is seeking. Harris wants to say, what I did was murder, but somebody else committed a murder far more heinous than mine. They didn't get the death penalty, therefore I shouldn't get the death penalty. The Supreme Court says California doesn't have to do that. That California has limited the death penalty to a small subclass of people by requiring the consideration of special factors, what we've previously talked about as aggravating circumstances. In other words, this is much like what the court said in Zant versus Stevens, when it upheld the Georgia law and said that what Georgia did with its aggravating circumstance was narrow the class of eligibles, narrow the people who are eligible for the death penalty, and that's really all the Eighth Amendment requires. The jury's discretion is limited by being directed to particular factors that say these factors weigh in favor of the death penalty or these do not. So the result of this case is quite significant because a number of states that had proportionality review statutes immediately repealed them. And a number of states that still had it on the books quit doing proportionality review, Georgia being one of them. Georgia had actually found some death sentences, the Georgia Supreme Court, disproportionate before this decision, but after this decision it has yet to find a death sentence disproportionate. So once again, we conclude here with the fact that the court takes a much narrower view of what the Eighth Amendment to the United States Constitution, what the Cruel and Unusual Punishment Clause requires. In the 1976 cases, the court was talking about the discretion of the sentencer being guided by clear and objective standards. Here, the court is simply saying, as long as you narrow the class, as long as the state narrows the class, says only people who commit murder in the commission of an armed robbery, or murder in the commission of a kidnapping, or however the court, the state, defines its aggravating circumstance, as long as that narrows the group of people that can be considered, that's all the Eighth Amendment requires. So that means Robert Alton Harris does not get a review of his case compared to others. He was put to death by the state of California, and it means that while there are some states, and Florida is one example of a state that still conducts proportionality review, and the Florida Supreme Court does, and this is not the only state, but the Florida Supreme Court does from time to time find that the death penalty is disproportionate. It looks at other states, other cases in the state, what punishment was imposed, and it builds some law there by its decisions in terms of when the death penalty is appropriate and when it's not. That provides some guidance to prosecutors in Florida and also to trial judges about when the death penalty is appropriate and when it's not. But that's not the case in most states, and any individual proportionality review can be done as a matter of state law, but it's not required by the Constitution of the United States.